Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
He never went to law school. He doesn't have a law degree. He cheated his way into one of New York's most prestigious law firms with a lie and a photographic memory. His name is Mike Ross, and he's the best closer the city has ever seen. He's brilliant, he's charming, he bends the rules, and he always finds a way to win. He is the perfect lawyer. And he is completely fake. But the idea of him, that's real. That idea has infected the minds of millions of Americans, and it's called the Mike Ross effect. It's the deeply ingrained belief, fed to us by decades of television, that lawyers are slick, omniscient superheroes who operate in a world of dramatic courtroom showdowns, last-minute evidence, and witty one-liners that bring juries to their feet. We see Harvey Specter close a hostile takeover and dismantle a witness in a mock trial in the same afternoon. We see Annalise Keating use devastating personal secrets to win unwinnable murder cases. We see Jack McCoy from Law and Order bend the very fabric of the Constitution to get a conviction in under an hour. We watch, we binge, and we absorb. And a dangerous thing happens. We start to believe it. A study by the American Bar Association found that nearly half of all Americans say their understanding of the justice system comes primarily from TV crime dramas. Think about that. For half the country, the foundation of their legal knowledge isn't civics class or the news. It's a fictionalized, dramatized, and fundamentally misleading script. And here's why that matters to you. Because one day you might not be watching the show. You might be in it. Not as a spectator, but as the client. You might be facing a DUI, a messy divorce, a contract dispute with a business partner, or a personal injury claim. And when you walk into a real lawyer's office, you're not going to find Mike Ross. You're going to find a real person operating in the real world, governed by real rules. And the massive gap between your TV-fueled expectations and the stark reality of the American legal system can be devastating. It can cause you to lose faith in your own case, to make terrible decisions, and to misunderstand the very person you're paying to help you. This is not just a video about debunking TV shows. This is about giving you a crucial reality check. We are going to deconstruct the most pervasive myths about the legal profession, one by one. We're going to replace Hollywood fiction with practical, powerful truths. By the time you finish this, you will understand the system better than 99% of the population. You will know what to look for in a lawyer, what to expect from the process, and how to become the most effective client you can be, armed not with fantasy but with knowledge. So let's start with the foundational lie, the one that underpins almost every other legal drama. It's the myth of the superhero generalist. On television, a great lawyer is simply a great lawyer, period. They are a master of all trades. In a single season of Suits, the firm Pearson Hardman handles corporate mergers, intellectual property theft, pro bono criminal defense, bankruptcy, and even international law. The main characters seem to possess an encyclopedic knowledge of every possible statute and piece of case law, ready to be deployed at a moment's notice. They are a Navy SEAL, an astronaut, and a brain surgeon all rolled into one impeccably dressed package. This is without a doubt the most insidious and misleading trope in the entire genre. In the real world, the law is not a puddle. It is an ocean. It is so vast, so deep, and so complex that the human mind cannot possibly master all of it. The days of the old-timey, small-town lawyer who could write your will in the morning, handle your land dispute in the afternoon, and defend you from a cattle-rustling charge in the evening are long, long gone. The modern legal profession is an industry of intense, almost microscopic specialization. Think about it this way: if you had a complex heart condition, you wouldn't go to your family doctor for surgery. You wouldn't even go to a general surgeon. You would go to a cardiothoracic surgeon who has spent their entire career, tens of thousands of hours, focused on that one single organ. The law is no different. Let's look at what this specialization actually means. A real-life corporate lawyer, the kind Harvey Specter pretends to be, spends the overwhelming majority of their time not in a courtroom, but buried in paperwork. Their world is due diligence, contract drafting, and regulatory compliance. They might spend 6 months on a single merger, reading thousands of pages of financial disclosures to identify potential liabilities. Their big showdown isn't a dramatic trial. It's a 14-hour conference call negotiating the indemnification clause in a stock purchase agreement. It is painstaking, meticulous, and requires a level of focused expertise that would be completely useless in a criminal courtroom. Now let's take a criminal defense attorney. Their entire professional life revolves around a completely different set of books, rules, and procedures. They understand the Fourth Amendment on search and seizure, the nuances of probable cause, and the intricacies of sentencing guidelines. They spend their days in courthouses, negotiating with prosecutors, filing motions to suppress evidence, and managing the fears of their clients. The vast majority of their cases, over 95% in the federal system, will end in a plea bargain, not a dramatic not guilty verdict from a jury. Asking this lawyer to suddenly handle a multi-million-dollar patent infringement case would be like asking a fish to climb a tree. They operate in different elements. Or consider a family law attorney. Their expertise is in divorce, child custody, and support. They have to be part lawyer, part therapist, part financial analyst. They navigate the most emotionally charged moments in a person's life, guided by state-specific statutes that a corporate lawyer would have no reason to know. And on it goes. There are tax attorneys, immigration attorneys, environmental lawyers, personal injury lawyers, real estate lawyers, and dozens of other specializations. Each one requires years of dedicated practice to achieve competence, let alone mastery. A lawyer who claims to be an expert in everything is an expert in nothing. So why does this myth matter so much? Because it sets you, the potential client, up for failure. When you believe in the superhero generalist, you might hire the wrong person for the job. You might ask the lawyer who handled your uncle's will to represent you in a complex medical malpractice suit. Because he's a good lawyer, right? That is a catastrophic mistake. That lawyer, however well-intentioned, will be out of their depth, facing an opponent who has spent their entire career in that specific arena. You will be bringing a knife to a gunfight. This myth also creates frustration. You might get angry when your lawyer tells you, "I can't advise you on the tax implications of this settlement. You'll need to speak with a tax attorney." On TV, that would be a sign of weakness. In reality, that is the sign of a competent, ethical professional who knows the limits of their expertise and is protecting your interests. They are not failing you. They are doing their job correctly. Recognizing that distinction is critical. So the first and most important piece of real-world legal advice is this: hire the specialist. When you are looking for a lawyer, you are not looking for a good lawyer. You are looking for the right lawyer. Look at their website. Does it list 20 different practice areas? That's a red flag. You want the lawyer whose website talks about one thing and one thing only, the exact problem you are facing. You want the person who has seen 100 cases just like yours, who knows the opposing lawyers, who knows the judges, and who lives and breathes that specific corner of the legal universe. We've shattered the myth of the all-knowing legal genius. We've replaced the image of the jack-of-all-trades with the reality of the focused specialist. But this brings us to the second, and perhaps more seductive, lie that television sells us. It's the one that takes place inside the courtroom itself. The dramatic last-minute confession from a surprise witness that blows the case wide open. The aha moment. In reality, that aha moment is almost guaranteed to get your lawyer sanctioned, the evidence thrown out, and your case potentially destroyed. And the reason why reveals one of the most fundamental and misunderstood principles of the entire American legal system. It's called discovery, and it's the single biggest reason why nearly every courtroom drama you've ever seen is a complete fantasy. Discovery is the formal pretrial process where both sides in a lawsuit are legally required to exchange information and evidence relevant to the case. Think of it as a mandatory show and tell for adults, where the stakes are freedom, money, or your entire future. The entire philosophy behind it is to prevent what the legal system calls trial by ambush. The goal of a modern trial is not to see which lawyer can pull the slickest, most shocking surprise out of their briefcase. The goal is to find the truth, and the system is built on the belief that the truth is most likely to emerge when both sides have access to the same set of facts, well in advance. Imagine a championship boxing match. Except one fighter is told they're fighting a heavyweight, but on fight night, a featherweight with knives taped to his gloves walks into the ring. It's an unfair fight because one side had no idea what they were preparing for. That's a trial without discovery. It becomes a game of theatrical tricks, not a methodical search for justice. By forcing both sides to lay their cards on the table beforehand, Discovery ensures that the trial is a contest of legal arguments and interpretations of the evidence, not a contest of who has the best private investigator digging up last-minute dirt. This process serves another, incredibly vital purpose. It keeps our entire legal system from grinding to a halt. The United States has the most litigious society on earth, but what most people don't realize is that the overwhelming majority of cases never actually see the inside of a courtroom. In the federal system, fewer than 2% of civil cases actually go to trial. For criminal cases, the number is similarly low, with over 95% being resolved through plea bargains. Why? In large part because of discovery. During discovery, both sides see the strength of the other's hand. The prosecutor sees the defense has a rock-solid alibi witness. The corporation suing a competitor sees emails proving their own executive was at fault. This reality check forces them to get serious about negotiating. It's in the months of depositions and document exchanges where the real battles are often won and lost. The case is settled, a plea deal is reached, and valuable court time is saved for the few, truly intractable disputes that must be decided by a judge or jury. Without this filtering process, our courts would be backlogged for decades. The dramatic trial is the exception, not the rule. The boring conference room meeting is the reality. So how does it actually work? It's not as simple as just swapping files. There are specific, powerful tools lawyers use. First, there are interrogatories. These are written questions that one party sends to the other, which must be answered under oath. Then there are requests for production of documents. This is the big one. It's a formal demand for any and all relevant documents, emails, contracts, text messages, internal memos, medical records, you name it. This is where the so-called smoking gun is usually found, not by a PI in a trench coat, but by a junior lawyer whose eyes are bleeding after reviewing 10,000 pages of financial reports. And most importantly, there are depositions. A deposition is sworn testimony given by a witness or a party before a trial. It takes place in a conference room, not a courtroom. There's a court reporter transcribing everything, and lawyers for both sides are present. This is where the dramatic cross-examination you see on TV actually happens. It's where Harvey Specter would grill a hostile witness for hours, probing for weaknesses, locking in their story so they can't change it later on the stand. By the time a witness takes the stand at trial, every lawyer in the room already knows exactly what they are going to say, because they've already been asked all the key questions, under oath months earlier. So when Mike Ross dramatically presents a surprise affidavit to a stunned witness on the stand, what would really happen? The opposing lawyer would leap to their feet and yell, "Objection, Your Honor." Counsel is attempting to introduce evidence not produced in discovery. And the judge would instantly reply, "Objection sustained." The jury will disregard that document. Then the judge would likely excuse the jury and proceed to tear Mike a new one. He would be sanctioned, possibly fined thousands of dollars. His firm would be sanctioned. The evidence would be thrown out. In a severe case, the judge could even declare a mistrial and make Mike's firm pay for the entire cost of the other side's legal fees. It's a catastrophic, career-ending blunder, not a brilliant winning move. This obsession with the gotcha moment feeds into another central myth of the TV lawyer, personified by Mike Ross himself, the lawyer as a superhuman genius with a photographic memory. Mike's eidetic memory is his defining feature. It allows him to instantly recall obscure legal precedents, notice tiny discrepancies in 1,000-page documents, and essentially function as a human version of the Google search engine. It's a fantastic narrative device. It provides a plausible, albeit fictional, reason for his meteoric rise without a law degree. It makes the law feel like a code that can be hacked by someone with sufficient brainpower. The reality of legal work is less glamorous. It's less about superhuman recall and more about superhuman persistence. Being a great lawyer isn't about having the entire US code memorized. It's about knowing how to find the right information. It's about meticulous, often mind-numbingly tedious research. Real lawyers don't rely on a magical memory. They rely on Westlaw and LexisNexis, sophisticated legal research databases that cost thousands of dollars a month. They rely on teams of paralegals, law clerks, and junior associates to spend hundreds of hours sifting through case law, statutes, and discovery documents. Legal practice is a team sport. The heroic solo practitioner who cracks the case alone at 3 a.m. is mostly a myth. It's a collaborative, grinding process of research, writing, strategy sessions, and endless revisions. The photographic memory trope is a lie, but it's a seductive one. It suggests that law is a field for an elite few with innate, God-given talent. But this does a massive disservice to the profession, and it creates an impossible standard for aspiring lawyers. Law students watch shows like Suits and feel like failures because they can't instantly recall the specifics of Marbury v. Madison from their first-year constitutional law class. The truth is, the skills that make a great lawyer are far more human and attainable. They are the ability to think critically, to write persuasively, to analyze a complex problem from multiple angles, and to communicate clearly and effectively. It's about discipline and hard work, not a genetic lottery ticket. The lawyer isn't a superhero. The process is the hero. The long, slow, methodical, and often boring process of building a case piece by painstaking piece. So if lawyers aren't pulling rabbits out of hats with surprise evidence, and they aren't human supercomputers, then what are they doing? The answer lies in the one thing TV gets most dangerously wrong: the lawyer's sacred and often conflicting duty. A duty that forces them to choose between their client, the court, and the truth itself. This three-way tug-of-war is the engine of the entire American legal system, and it's the place where television gets its fuel, but burns the wrong kind. Let's start with the one TV gets half right, the one that makes for the best drama. The absolute, almost sacred duty to the client. In the legal world, this is called zealous advocacy. It's the idea that your lawyer is your champion, your gladiator. They are required, by the very ethics of their profession, to fight for you with every legal tool at their disposal. This is where the famous lawyer-client privilege comes in. Anything you tell your lawyer in confidence, for the purpose of getting legal advice, is locked in a vault. Your lawyer cannot be forced to repeat it. Not to the police, not to a prosecutor, not even to a judge under oath. It is one of the oldest and most powerful privileges in common law. On shows like Suits, this privilege is treated like a superpower. Harvey Specter or Mike Ross will lean in, the camera tight on their face, and say, "Tell me everything." It's privileged. And the client unburdens themselves of corporate espionage, financial fraud, you name it. The lawyer becomes the keeper of secrets, the one person in the world who knows the whole truth and will use it to protect you. And in that sense, TV isn't entirely wrong. This protection is incredibly broad. If a client tells their lawyer, "I did it. I robbed the bank," that confession is sealed. The lawyer cannot go to the police. In fact, if they did, they would be disbarred. Their job from that moment forward is to make the prosecution prove their case beyond a reasonable doubt, using every legal means to challenge the evidence, even knowing their client is factually guilty. It's a concept that feels wrong to a lot of people, but it's the bedrock of the system. Without it, no one would ever be honest with their lawyer, and the right to a proper defense would be impossible. But here is where television executes a perfect cinematic lie of omission. It presents this privilege as an unbreakable shield, a moral get-out-of-jail-free card. It almost never shows you the massive exception, the line in the sand that a lawyer can never ever cross. It's called the crime-fraud exception. While a lawyer must keep your past crimes secret, they are forbidden from helping you commit a future crime. So if the client says, "I robbed the bank last Tuesday," that's privileged. But if they say, "I'm going to rob another bank next Tuesday, and I need you to help me launder the money," the shield shatters. Not only is the conversation not privileged, but the lawyer now has an ethical, and in some cases legal, obligation to act. They might have to withdraw from the case, or in extreme situations where there's a threat of imminent death or substantial bodily harm, they may even be permitted to disclose the information to prevent it. Think about how many TV plots this would instantly destroy. The fixer who helps a client hide a body? That lawyer is now an accessory to murder. The corporate attorney who helps draft contracts to cover up an ongoing fraud scheme? They're part of a criminal conspiracy. On TV, lawyers are partners in the scheme. In reality, the moment they knowingly assist in a future or ongoing crime, they stop being a lawyer and start being a co-defendant. This brings us to the second, far less glamorous duty, the duty to the court. If the duty to the client is the gas pedal, the duty to the court is the brake. Every single lawyer, when they are sworn in, becomes an officer of the court. This is a title you almost never hear on television, because it's the direct enemy of primetime drama. Being an officer of the court means you have a duty of candor, a duty to be honest and not mislead the judge or the opposing party. It means you cannot knowingly present false evidence. You cannot lie to the court, ever. Now think about how this directly clashes with being a zealous advocate. Let's play this out. Your client, who privately told you he robbed the bank, decides he wants to testify. He wants to get on the stand in front of the jury and say, "I didn't do it. I was home watching a movie." What does the TV lawyer do? They prep their client, they rehearse the lie, and they sit there stone-faced while their client commits perjury, because their only job is to win for the client. That's the Mike Ross playbook. What does a real lawyer do? They have an ethical meltdown. This is one of the worst situations a lawyer can be in. First, they must try to convince their client not to lie. They'll explain that perjury is a separate crime, that the jury will likely see through it, that it's a terrible idea. But what if the client insists? The lawyer cannot, under any circumstances, participate in presenting false testimony. They can't ask the client questions they know will lead to a lie, like, "So, where were you on the night of the robbery?" The lawyer is trapped. They can't tell the judge, "My client is about to lie," because that would violate their duty to the client and the attorney-client privilege regarding the past confession. But they also can't let the client lie, because that would violate their duty to the court. The real-world solution is a bizarre and awkward legal dance. The lawyer might have to inform the judge they have an ethical conflict and need to withdraw from the case, without explaining why. Or, in some jurisdictions, they have to allow the client to testify in a strange narrative form. The lawyer will ask a single open-ended question like, "Is there anything you want to tell the jury?" And then they will step back and let the client speak, without asking any follow-up questions. This signals to the judge, and often the prosecutor, that the lawyer is ethically firewalling themselves from the testimony. It's clunky, it's career-threatening, and it's the absolute opposite of the slick, controlled drama you see on TV. There are no gotcha moments, just a slow-motion train wreck of conflicting ethical obligations. And that brings us to the third point of this triangle, the truth. If a lawyer has a duty to the client and a duty to the court, where does the actual objective truth fit in? This is the most profound misunderstanding created by legal dramas. We are conditioned to believe that a trial is a search for the truth. The brilliant lawyer like Perry Mason, through clever questioning and last-minute evidence, reveals what really happened, and the innocent person goes free. This is a comforting fantasy. The American justice system is not a truth-finding machine. It is an adversarial system. It's a structured battle between two opposing sides, operating under a strict set of rules of evidence and procedure. The system is designed with the belief that the closest version of the truth will emerge when two zealous advocates throw everything they legally can at each other, with the judge acting as a referee. A lawyer's job is not to find the capital T truth. Their job is to represent their client's version of events, their client's interests, as effectively as possible using the legally admissible evidence. They don't have to believe their client is innocent. They don't have to solve the crime. They have to poke holes in the prosecution's case. They have to argue that the evidence presented doesn't meet the impossibly high standard of beyond a reasonable doubt. A criminal defense lawyer can put on a full, powerful defense for a client they know is guilty. And not only is that legal, it is their ethical obligation. They are testing the government's evidence. That is their function. They are a quality control check on the state's power to take away a person's liberty. So when you see Mike Ross or Harvey Specter sending their investigators to dig up the real killer, they aren't acting like lawyers. They're acting like private detectives in $1,000 suits. They are pursuing an objective truth, when a real lawyer's world is one of legal truth. A truth defined only by what can be proven in court. This fundamental conflict, this messy and perfect balancing act between client, court, and truth, is the daily reality for every lawyer in America. But it's a reality that doesn't fit neatly into a 42-minute episode. So instead, television gives us a hero who can magically serve all three masters at once. A hero who, by being cleverer and more righteous than the system itself, can champion his client, honor the court, and reveal the absolute truth, all before the credits roll. And that illusion warps our understanding of what justice actually looks like in the place where these duties collide with the most explosive force. The American courtroom. The American courtroom, as seen on TV, is a theater of confrontation. It's an arena where two legal gladiators clash, and the climax, the moment we all wait for, is the dramatic cross-examination. A witness takes the stand confident, maybe even a little smug. Our hero, the brilliant lawyer, circles them like a shark. The questions start simple, lulling them into a false sense of security. Then the pivot. A question so sharp, so unexpected, it cuts through every rehearsed lie. The witness stammers. Sweat beads on their forehead. The lawyer presents a single damning piece of evidence they've been hiding until this exact moment. The witness breaks down, sobbing, confessing everything right there on the stand. "I did it. I couldn't let him get away with it." Sometimes they even point to the real killer sitting silently in the back of the gallery. The judge bangs the gavel, justice is served, and the case is closed. This is the Perry Mason moment. A trope so powerful it has defined the fictional courtroom for over 60 years. From Perry Mason himself, who famously extracted confessions on the stand in nearly every episode, to Ben Matlock, to Jack McCoy on Law & Order, to Annalise Keating orchestrating chaos in How to Get Away with Murder. It is the single most persistent and most misleading myth about the American legal system. Because in the real world, the Perry Mason moment is pure fantasy. It doesn't happen. And the reason it doesn't happen comes down to two of the least dramatic words in the English language: rules and procedure. The first wall this fantasy crashes into is the rules of evidence. You've heard the phrase 1,000 times. Objection, Your Honor. On TV, it's often used as a generic way to interrupt the other lawyer. In reality, an objection has to be based on a specific rule being broken. And these rules are designed precisely to prevent the kind of dramatic free-for-all you see on screen. Consider the biggest rule: hearsay. Hearsay is, in simple terms, an out-of-court statement being used to prove that the statement itself is true. If a witness says, "I saw the defendant run the red light," that's testimony. If they say, "My friend Bob told me he saw the defendant run the red light," that's hearsay. You can't cross-examine what Bob said. Bob isn't there. His statement can't be tested. In a real court, the opposing lawyer would be on their feet instantly. Objection. Hearsay. And the judge would sustain it. Yet, on TV, characters constantly testify about what other people told them, saw, or felt, because it's an easy way to move the plot forward. Then there's speculation. A witness can only testify to things they have direct knowledge of. They can't guess what was in someone else's mind. A TV witness might say, "I could tell he was angry and was probably going home to get his gun." In a real courtroom, objection calls for speculation. The witness doesn't know what the person was thinking or what they were going to do. They can only say, "He looked angry. His fists were clenched and his face was red." The jury can draw its own conclusions from there. Or what about relevance? Lawyers can't just bring up a defendant's past misdeeds from 20 years ago to make them look like a bad person. The evidence has to be relevant to the specific charges at hand. Harvey Specter might bring up a rival CEO's messy college divorce to fluster him on the stand, but in reality, a judge would shut that down immediately. Counselor, what is the relevance of this line of questioning? These rules aren't just boring technicalities. They are the bedrock of a fair trial. They ensure that a verdict is based on reliable, testable evidence, not on gossip, guesswork, or character assassination. But they are also the enemy of good drama. They're designed to keep things controlled, focused, and frankly a little bit boring. But the real stake through the heart of the Perry Mason moment is a process called discovery. This is the single biggest difference between a real trial and a TV trial. On television, a trial is a game of surprises. Lawyers hide their trump cards, conceal their star witnesses, and spring gotcha evidence at the most dramatic moment. In the real world, that's not just forbidden, it could get a lawyer disbarred. The discovery process mandates that before a trial even begins, both sides, the prosecution and the defense, have to show each other almost all of their cards. They exchange witness lists, police reports, expert witness reports, physical evidence, documents, emails, text messages, everything. If the prosecution has a smoking gun email, they are legally required to give a copy to the defense months in advance. If the defense finds a surprise witness who can provide an alibi, they have to notify the prosecution. The entire system is built on a foundation of no surprises. The goal is for both sides to be able to fully prepare their case based on the same set of known facts. A lawyer who tried to hide a key piece of evidence until trial, like Mike Ross finding a crucial memo the night before his big courtroom showdown, wouldn't be hailed as a genius. He'd be sanctioned by the judge, the evidence would be ruled inadmissible, and he might even cause a mistrial, torpedoing his own case. So, if there are no confessions on the stand and no surprise evidence, what is the real point of cross-examination? It's not about a single knockout punch. It's about a death by 1,000 cuts. A real lawyer's goal on cross-examination is to slowly and methodically chip away at a witness's credibility. They aren't trying to make them confess to the crime. They're trying to make the jury doubt their testimony. They do this by asking precise, controlled, often mind-numbingly dull questions. They'll get a witness to admit that their view was partially obstructed. They will highlight a tiny inconsistency between their testimony today and what they told police a year ago. They'll show that the witness has a personal bias against the defendant. Each question is a tiny brick. The lawyer isn't trying to build a cathedral in a single moment. They're trying to build a wall of reasonable doubt, one small, unexciting brick at a time. The real drama isn't in a sudden explosion of truth, but in the slow, meticulous dismantling of a story. This is where the Mike Ross archetype, the savant with the photographic memory, truly warps our expectations. We see him win cases because he can instantly recall a single sentence from page 847 of a 1,000-page document during a high-pressure trial. This perpetuates the myth that law is about moments of spontaneous genius. The reality is that law is about preparation. The case isn't won in the courtroom. It's won in the months or years leading up to it. It's won by the associate who spent 300 hours in a windowless room reviewing those 1,000 pages, flagging that one sentence, and putting it into a carefully prepared trial binder for the lead attorney. The trial itself is merely the final public performance of that exhaustive behind-the-scenes labor. The TV courtroom is a high-stakes poker game, where victory depends on bluffs, tells, and the shocking reveal of a hidden ace. A real courtroom is more like a game of chess where both players have been studying the board and all the pieces for a very long time. The tension isn't in the surprise, it's in the strategy. But that slow, methodical strategy, governed by strict rules and procedures, simply doesn't make for good television. So we get the fantasy instead. And that fantasy has convinced us that the courtroom is where the main event of justice takes place. But what if I told you that for over 95% of cases in America, the story ends long before anyone ever says, "All rise"? That number sounds insane, right? 95%. In some jurisdictions, it's closer to 98. It's a statistic that feels fundamentally wrong, like a glitch in the matrix of our justice system. We're raised on stories of heroic lawyers making impassioned closing arguments to a jury of 12 ordinary citizens. The trial is the climax, the crucible where truth is forged. So how can it be that the centerpiece of our entire legal drama almost never actually happens? The answer lies in a simple, brutal reality of the American legal system. It is designed to avoid trials at all costs. Trials are unpredictable, they are obscenely expensive, and they are incredibly time-consuming. For the courts, they are a logistical nightmare, clogging up dockets for months or even years. For the lawyers and their clients, they are a massive gamble. You could have the perfect case, the smoking gun email, the star witness, and still lose because a jury didn't like the color of your client's tie. The system, therefore, has built-in pressure release valves to prevent the vast majority of cases from ever reaching that boiling point. In criminal law, that valve is called the plea bargain. In civil law, it's called a settlement. And this is where the real work of 99% of lawyers actually happens, not in a courtroom but in a conference room. On television, accepting a plea deal is almost always portrayed as a sign of defeat. It's the moment the idealistic young lawyer has to tell their innocent client that the system is broken, and their only choice is to admit to a crime they didn't commit to avoid a catastrophic sentence. Or it's the moment the villain, cornered by Harvey Specter's brilliant maneuvering, is forced to take a deal to avoid total annihilation. In either case, it's a compromise, a failure to achieve pure, unadulterated victory in open court. But in the real world, the plea bargain isn't the failure of the system. It is the system. Prosecutors have immense power. They decide what to charge you with, and they can often stack charges so high that the potential sentence you'd face at trial is terrifying. Imagine you're accused of a crime, and you're innocent. Your lawyer tells you that if you go to trial and lose, you're facing a mandatory minimum of 10 years in prison. But the prosecutor is offering a deal. Plead guilty to a lesser charge and you'll get 2 years, maybe even just probation. You know you're innocent. But can you risk rolling the dice on a jury and losing a decade of your life? What if your public defender is overworked and can't possibly give your case the attention it needs? What if the evidence against you, while misleading, looks bad on paper? For millions of people, that choice is no choice at all. They take the deal. The prosecutor gets a guaranteed conviction on their record, the judge clears a case from their docket, and the system churns on. No trial, no dramatic cross-examination, no "you can't handle the truth" moment. Just a signature on a piece of paper in a quiet, sterile room. The same logic applies to the civil world of suits. The high-stakes corporate lawsuits we see are almost never resolved by a jury verdict. They end in settlements. Why? Money. A complex corporate lawsuit can cost millions, sometimes tens of millions of dollars in legal fees before you even see the inside of a courtroom. The process that precedes a trial is a financial war of attrition. It's called discovery, and it's the single most important and least televised part of any lawsuit. Discovery is the phase where each side is legally required to hand over all relevant information to the other. Emails, internal memos, financial records, text messages, everything. On TV, this is the part Mike Ross does in a single all-nighter, fueled by coffee and sheer genius, where he stumbles upon the one smoking gun document buried in a mountain of boxes. The reality is a soul-crushing slog that can take years. We're not talking about a few boxes, we're talking about terabytes of data, millions of electronic documents. The legal teams use sophisticated software to search for keywords, but a human still has to review tens of thousands of those documents for relevance and privilege. This is the real life of a junior associate at a big law firm. Not snappy banter and high-stakes bluffs, but endless hours in a windowless room, reviewing spreadsheets and email chains until your eyes bleed. And the company with the deeper pockets has a massive advantage. They can afford to pay a larger army of lawyers and paralegals to sift through data. They can also use it as a weapon, burying the other, smaller side in so many document requests and procedural motions that they run out of money just trying to keep up. They force you to spend $1 million just to get to the starting line, hoping you'll tap out and accept a lowball settlement offer. This is the real corporate rating. It's not done with clever loopholes. It's done with brute financial force during discovery. The case is often won or lost right here, based on who has the endurance to survive this phase. Then there are the depositions. This is the closest the pre-trial phase gets to courtroom drama, and it's arguably more intense. A deposition is a formal, sworn testimony given by a witness or a party in the case. But it doesn't happen in court. It happens in a law firm's conference room. Imagine sitting at a long, polished table. Your lawyer is next to you, but they can't answer for you. Across from you are 3, maybe 4 lawyers from the other side. A court reporter sits at the end of the table, silently transcribing every single word, every stutter, every sigh. For the next 7 or 8 hours, it is their job to grill you. They will ask you the same question 5 different ways, trying to catch you in a contradiction. They will be friendly, then aggressive. They will twist your words. They will take you through every email you've sent for the past 5 years. There is no judge to say objection. Your lawyer can instruct you not to answer in very rare circumstances, but for the most part, you are on your own. It is a grueling psychological marathon designed to wear you down, lock you into your story, and see how you'll hold up under pressure. A witness who cracks in a deposition will likely never be put in front of a jury. The lawyers see the weakness and know exactly how to exploit it. Entire multi-million-dollar cases can hinge on a single disastrous deposition, and it all happens behind closed doors, completely invisible to the public. So when Harvey Specter confidently strides into a courtroom, he's not just armed with his wit and a perfectly tailored suit. In the real world, he'd be armed with thousands of hours of document review, dozens of deposition transcripts, and a mountain of legal bills his client has paid. The trial, if it ever happens, isn't a spontaneous performance. It's a carefully scripted play where every line, every piece of evidence, and every witness's testimony has been rehearsed and wargamed for months, if not years, during discovery. The lawyers already know what the other side has. They know what the witnesses will say because they've already asked them in a deposition. The surprises you see on TV, the last-minute witness, the shocking piece of evidence nobody knew about, are largely fiction. In real litigation, a surprise like that would get a lawyer sanctioned by the judge and could cause a mistrial. The Mike Ross effect convinces us that the defining skill of a lawyer is public speaking and quick thinking on their feet. The reality is that the defining skills are project management, insane attention to detail, and a high tolerance for tedium. The war isn't won with a knockout punch in the 12th round. It's won by 1,000 tiny paper cuts in the months leading up to it, until one side finally bleeds out and is forced to surrender. This is the engine room of the American legal system. It's not glamorous, it's not inspiring, and it's where the overwhelming majority of justice is actually decided. But this system, a system built on deals and out-of-court pressures, creates a much darker and more troubling consequence. What happens when the pressure to make a deal, the pressure to avoid the risk and expense of a trial, is so immense that it completely overrides the truth? What happens when innocence is no longer a shield? You get what's known as the innocence penalty. It's a term that should send a chill down your spine. It describes one of the most perverse and terrifying glitches in the American justice system. The phenomenon where defendants who maintain their innocence, reject a plea deal and exercise their constitutional right to a trial, are punished with a significantly harsher sentence if they're found guilty than the one they were originally offered. It is, in essence, a penalty for believing in your own innocence. A tax on demanding your day in court. On television, this concept is completely alien. Can you imagine Harvey Specter looking an innocent client in the eye and saying, "Listen, I know you didn't do it. You know you didn't do it. But the DA is offering you 5 years. If we go to trial and lose, you're getting 30. So I need you to stand up in court and lie. I need you to say you're guilty." It's unthinkable. It would shatter the entire premise of the show. The hero lawyer doesn't cut deals for the innocent. The hero lawyer fights. They go to trial, they expose the real killer on the stand, they deliver a closing argument that moves the jury to tears, and they win. The trial is the entire point. It's the crucible where truth is forged. In the real world, the trial is a statistical anomaly, and for an innocent person it can be a death trap. Consider the story of John Cogut. In 1985, he was a bouncer at a bar in Long Island, New York. He was accused of the horrific rape and murder of a 16-year-old girl. The evidence against him was thin, resting almost entirely on a confession he claimed was coerced after hours of intense, deceptive interrogation, a confession he immediately recanted. He insisted he was innocent. The prosecutors, perhaps seeing the weakness in their own case, offered him a plea bargain. Plead guilty and you'll be eligible for parole in a few years. It was a classic offer, a door out of the nightmare. All he had to do was admit to a crime he swore he didn't commit. John Cogut refused. He couldn't do it. He believed in the system. He believed a jury of his peers would see the truth. He rolled the dice. He went to trial, was convicted, and was sentenced to 25 years to life in prison. He paid the innocence penalty. For nearly 2 decades, John Cogut sat in a maximum security prison. An innocent man living a nightmare because he refused to lie. He lost everything. His youth, his freedom, his name. All because he did exactly what every TV show, every movie, every piece of legal fiction we consume tells us an innocent person should do. He fought. Meanwhile, the real killer was free. It wasn't until 2003, after years of legal battles by new lawyers, that advanced DNA testing, unavailable at the time of his trial, proved conclusively that he was not the perpetrator. The DNA found at the scene matched another man entirely. John Cogut was finally exonerated and set free. His story isn't a 1 in a million fluke. It's an extreme example of a routine calculation. A 2018 report by the National Association of Criminal Defense Lawyers found that the average sentence for a federal narcotics defendant who goes to trial is 3 times longer than the sentence for a defendant who pleads guilty. For fraud, it's 5 times longer. For robbery, it's 6 times longer. The message the system sends is brutally clear. Don't waste our time. Don't make us prove our case. Take the deal we give you or we will make you regret it. This is the trial tax. It's a surcharge levied against you for exercising your Sixth Amendment right. And it explains why over 97% of federal convictions and 94% of state convictions are the result of guilty pleas. It's not because 97% of defendants are caught red-handed with a mountain of irrefutable evidence against them. It's because many of them, guilty and innocent alike, are simply too terrified to take the risk. Imagine yourself in that interrogation room. You're innocent. You know it in your bones. But the evidence is confusing. A witness misidentified you. The police think you're lying. The prosecutor sits across from you and lays out the choice. It's not a choice between freedom and prison. It's a choice between a definite, manageable amount of prison or a potentially life-destroying amount of prison. They offer you 3 years. But if you fight it and a jury doesn't believe you, the judge could give you 20. Your lawyer, a public defender juggling 200 other cases, advises you that juries are unpredictable. He tells you he's seen innocent people get convicted. What do? Do you bet your entire life on the hope that 12 strangers will believe you? Or do you take the certain lesser punishment, swallow your pride, and lie to the world just to guarantee you'll see your family again before you're old? This is the grim reality that television completely sanitizes. On Better Call Saul, Jimmy McGill's plea negotiations are a clever game of haggling and manipulation, a performance to get the best deal for his often guilty clients. It's portrayed as a necessary, if slightly grimy, part of the legal hustle. What it fails to show is the crushing, coercive power of that negotiation when it's aimed at an innocent person. It's not a bargain, it's a threat. The plea isn't an option, it's an ultimatum. This pressure to plead guilty doesn't just affect the innocent defendant. It corrupts the entire system. It allows sloppy police work to go unchallenged. It allows shaky evidence to go unexamined. It allows prosecutors to secure convictions in cases they might not be able to win at trial. clearing their dockets and boosting their conviction rates. The assembly line keeps moving. The truth becomes a secondary concern, an expensive luxury that the system is not designed to accommodate. In the world of TV law, a prosecutor's primary motive is justice. In the real world, a prosecutor's primary metric of success is their conviction rate. And nothing is better for a conviction rate than a steady stream of guilty pleas. So while we watch Mike Ross or Alicia Florrick risk everything on a dramatic trial, we are absorbing a fundamental falsehood about where American justice actually happens. It doesn't happen in a majestic courtroom with a brilliant lawyer hypnotizing a jury. It happens in a small windowless office, where a tired, overworked public defender and a pragmatic prosecutor make a calculated decision about how many years of a person's life are worth trading for systemic efficiency. The heroic trial is a lie. The mundane, terrifying plea bargain is the truth. This systematic pressure to plead guilty, this trial tax, fundamentally warps the search for truth. But it's not the only way our TV-fueled expectations collide with reality. Because even when cases do go to trial, what we think of as ironclad evidence, the smoking gun, the DNA match, the perfect fingerprint, is often anything but. The CSI effect has created a myth of scientific certainty that is just as dangerous, and just as misleading, as the myth of the heroic trial lawyer. And this is where the myth of perfect science collides with the myth of perfect lawyering. Because on television, this flawed, human, and often ambiguous evidence is always handled by a genius who finds the one, single, undeniable truth hidden within it. It's the legal drama's most sacred trope, the eureka moment. You know exactly what I'm talking about. It's 2 a.m. Our hero lawyer, be it Harvey Specter, Annalise Keating, or even the venerable Jack McCoy, is alone in their office. The city skyline glitters outside the window. They're surrounded by stacks of files, empty coffee cups, and takeout containers. They look exhausted, defeated. The case is falling apart. And then their eyes catch something. A misplaced comma in a contract. A name on a visitor's log that shouldn't be there. A financial statement where the numbers are too perfect. Their eyes widen. The music swells. They grab the document, their hands shaking with revelation. They've found it. The one thing. The silver bullet. The key that unlocks the entire conspiracy. The next scene, they're storming into court or a deposition, slamming that piece of paper down on the table and declaring, "Checkmate." The opposition is stunned. The case is won. The credits roll. This is the promise of the Mike Ross effect. Mike, with his photographic memory, is the living embodiment of this fantasy. He doesn't just read documents. He absorbs them, holding millions of data points in his mind until the one critical inconsistency reveals itself. He is a human search engine for smoking guns. And shows like Suits train us to believe that this is how the law works. That every complex legal battle, every multi-billion-dollar lawsuit, hinges on a single brilliant discovery. That victory is an act of sudden, dramatic revelation. The reality? It's less like a lightning strike and more like tectonic plates grinding against each other for a million years to build a mountain. A real case isn't one with one piece of paper. It's one with 100,000 pieces of paper. The process isn't called the revelation. It's called discovery. And it is, without a doubt, the most expensive, time-consuming, and soul-crushingly tedious part of the entire legal profession. It's the part they never show you on TV because if they did, you'd change the channel. Imagine a massive corporate lawsuit, not between two individuals, but two global tech giants. The dispute isn't over a single broken contract. It's over a decade of alleged patent infringement and anti-competitive practices. The amount of evidence isn't a box of files. It's petabytes of data. Millions of emails, internal memos, chat logs, source code revisions, financial projections, and PowerPoint presentations. The TV solution? Mike Ross gets locked in a room for a weekend, fueled by pizza and an eidetic memory, and emerges on Monday morning with the one incriminating email chain that proves everything. The real-world solution? A company hires a law firm, which then staffs the case with a team. A few partners, several senior associates, and a small army of junior associates and paralegals. This army doesn't descend upon a library. They descend into what's affectionately known as the doc review dungeon. It's often a windowless conference room in the basement of the office building, filled with dozens of contract attorneys working for an hourly wage, staring at computer screens for 10 hours a day, 6 days a week, for months on end. Their job is not to find a smoking gun. Their job is to perform the legal equivalent of panning for gold. Except they're sifting through a river of digital sludge. They use sophisticated e-discovery software to run search terms. They read through thousands upon thousands of documents, and for each one they click a button. Is it responsive to the case? Is it privileged and therefore protected? Does it contain hot information? They aren't looking for the one email that says, "Let's commit this massive fraud tomorrow at 9 a.m." That email doesn't exist. People, especially corporate executives, are rarely that stupid. Instead, they are building a mosaic. They are looking for 100 different things that, when pieced together, tell a story. An email from an engineer in 2014 warning about a potential design flaw. A memo from a mid-level manager in 2016 dismissing that concern due to budget constraints. A financial report from 2018 showing increased profits from the very product with the flaw. A chat log where two executives use coded language to talk about managing the narrative. None of these things on their own is a smoking gun. The engineer's email can be explained away as a standard part of the design process. The manager's memo can be framed as a reasonable business decision. The financial report is just numbers. But together, woven together by a skilled lawyer over the course of a long, grueling deposition or a trial presentation, they become a tapestry of liability. They tell a story of knowledge, intent, and consequence. The win doesn't come when a lawyer slams a single document on a table. The win comes when, after a 7-hour deposition, an opposing CEO is forced to admit, under oath, that he saw that 2014 email, that he approved that 2016 memo, and that he was aware of those 2018 profits. It's a victory of 1,000 tiny cuts. A death by paper. It is a slow, methodical, and profoundly uncinematic grind. This myth of the eureka moment has damaging consequences. It creates an utterly warped expectation for clients. They come to a lawyer with a problem and expect a wizard. They don't understand why their lawyer can't just find the thing that will make their problem go away. They are shocked when they get the first bill and see hundreds of hours logged for document review. They ask, "What have you been doing?" The answer, "Reading your opponent's emails one by one," sounds unproductive, even incompetent, to someone raised on a diet of courtroom drama. And it affects juries. Just like the CSI effect makes them expect flawless DNA evidence for every crime, the Mike Ross effect makes them expect a dramatic, case-closing reveal. When a prosecutor presents a complex circumstantial case, built from dozens of small interconnected pieces of evidence, the jury can be left feeling unsatisfied. They're waiting for the Perry Mason moment, that aha, the dramatic confession on the stand. When it never comes, they might confuse the lack of drama with a lack of evidence. They might think, if the case were really strong, there'd be a smoking gun. The truth is, the vast majority of legal work is about managing overwhelming amounts of information, not unearthing secrets. It's about organization, not revelation. It's about endurance, not genius. The real legal superhero isn't the person who can find the needle in the haystack. It's the person willing to meticulously label and categorize every single piece of hay. But this focus on the how, the mechanics of winning a case, ignores an even bigger myth perpetuated by television. The myth of why. On TV, the lawyer isn't just a brilliant strategist, they are a moral crusader. They fight for the innocent, they take down the corrupt, they speak truth to power. They are agents of justice. Harvey Specter, for all his arrogance, is almost always fighting for a client who, in the end, we are meant to see as being on the right side of the issue. It's a comforting thought that these brilliant minds, these masters of the system, are fundamentally driven by a desire to do good. But is that the reality of the profession? Is a lawyer's primary duty to justice? Or is it to something else entirely? Something far more complicated and, to many, far more troubling? The answer, according to the American Bar Association's Model Rules of Professional Conduct, is not justice. Not in the way we think of it, anyway. A lawyer's primary, sworn, ethical duty is to their client. This is the principle of zealous advocacy. It dictates that a lawyer must do everything legally and ethically possible to advance their client's interests, regardless of their own personal feelings about the client or the case. They are not an impartial judge of facts. They are a hired champion. This is the single biggest, most fundamental disconnect between the lawyers we see on television and the lawyers who practice in the real world. Because on TV, the lawyer's ultimate loyalty is almost always to the truth. When Mike Ross or Alicia Florrick discover their client is truly the villain, they experience a crisis of conscience that leads them to maneuver the situation toward a just outcome. They might trick the client into a confession, or secretly feed information to the other side. They become agents of a higher narrative justice. In reality, doing that would get a lawyer disbarred. It would be a catastrophic breach of their most sacred professional duty. This isn't because the legal profession is immoral. It's because the entire American legal system is built on a specific, and often misunderstood, framework, the adversarial system. Imagine two prize fighters in a ring. One represents the prosecution or the plaintiff. The other represents the defense. Each fighter's job is not to figure out who is the better person overall. Their job is to fight as hard and as effectively as they can under the established rules. In the center is a neutral referee, the judge or the jury. The core belief of the adversarial system is that the truth is most likely to emerge from this structured conflict. By having two opposing sides present the most compelling version of their own case, a neutral observer can best weigh the evidence and arrive at a just conclusion. A lawyer in this system is not a seeker of objective truth. They are a presenter of a biased perspective. Their job is to take their client's version of events and build the strongest possible argument around it, while simultaneously poking every conceivable hole in their opponent's argument. The prosecutor does the exact same thing for the state. Justice isn't the goal of the individual participants. Justice is supposed to be the product of their collision. This leads us to the classic uncomfortable question that television loves to ask, but rarely answers honestly. What does a lawyer do when they know their client is guilty? On screen, this is the ultimate moral test. The lawyer sweats, they agonize, they stare out their high-rise office window at the city lights, contemplating the nature of good and evil. Often, the show gives them an easy way out. A last-minute plot twist reveals the client was innocent all along, framed by a surprise villain. Hooray! Our hero's morality is preserved. But what happens in the real world, where things are not so neat? The first thing to understand is that a lawyer cannot lie to the court. They cannot knowingly present false evidence, and they cannot allow their client to get on the stand and commit perjury, that is, lie under oath. If a client insists on testifying and lying, the lawyer has an ethical obligation to withdraw from the case or inform the court, a complex situation lawyers call a narrative problem. However, and this is the crucial part, a defense attorney's job is not to prove their guilty client is innocent. Their job is to hold the government to its burden of proof. The Fifth and Sixth Amendments to the Constitution guarantee due process and the right to counsel. This means that every single person accused of a crime, regardless of their guilt, is presumed innocent until the state can prove otherwise, beyond a reasonable doubt. The defense lawyer is the instrument of that doubt. Their role is to challenge the legality of the state's actions. Was the evidence obtained with a valid warrant? Was the confession coerced? Is the eyewitness testimony reliable? Can the chain of custody for the murder weapon be verified without any gaps? Think of a defense attorney for a guilty client not as a liar, but as the world's most aggressive quality control inspector. The prosecution has built a product, its case for conviction. The defense attorney's job is to kick the tires, stress test the materials, and search for any crack, any flaw, any weakness in its construction. If the case is shoddy, if the police violated rights to get evidence, if the prosecution's theory doesn't hold up to scrutiny, then the product is defective. And in the American legal system, a defective product cannot be used to take away a person's liberty. This is the safeguard that protects all of us. Because if the government can cut corners to convict a person who is obviously guilty, it creates a precedent that allows them to cut corners to convict anyone. This is why the reality of law is so much less satisfying than television. A TV lawyer's victory is finding the real killer. A real lawyer's victory might be getting a known drug dealer's case dismissed because the arresting officer's search was unconstitutional. On TV, that's a failure of justice. In the real world, it's a victory for the principle that our rights matter, and that the government must follow the rules, no matter who the defendant is. We almost never see a show about a public defender who spends 80 hours a week filing motions to suppress evidence, because the procedural, unglamorous work of holding the system accountable doesn't make for gripping television. It's far more dramatic to have a lawyer like Harvey Specter say, "I don't play the odds, I play the man," than to show him spending a month reviewing 10,000 pages of financial documents in a process called discovery. And what about the other side? The prosecutors. On shows like Law and Order, they are the righteous warriors, the good guys fighting to put criminals behind bars. Their ethical duty is in fact different and in many ways higher than a defense attorney's. While the defense attorney's duty is to their client, a prosecutor's client is, in essence, the public. Their duty is not simply to win, but to seek justice. This is a profound distinction. It means that if a prosecutor comes across evidence that suggests the defendant might be innocent, what's known as exculpatory evidence, they have a constitutional obligation to turn it over to the defense, even if it completely destroys their own case. This is known as the Brady Rule. A prosecutor who hides evidence to secure a conviction isn't just a TV villain. They are committing a severe ethical and legal violation that can lead to a conviction being overturned and the prosecutor being disbarred. So the TV trope of the ruthless prosecutor who will stop at nothing to get a win is often a dramatic exaggeration. While prosecutorial misconduct is a real and devastating problem, the ethical foundation of their role is to be a minister of justice, not just a winning attorney. The system is designed with these opposing and very different duties in mind. The defense attorney's zealous advocacy for the individual is meant to be balanced by the prosecutor's duty to objective justice for society. It's a messy, imperfect, and deeply human system. It's a system where the lawyer's role is not to be a hero who magically finds the truth, but to be a dedicated mechanic within a complex machine. Their personal belief in their client's guilt or innocence is, and must be, irrelevant to the execution of their duty. This is the uncomfortable, unglamorous, and absolutely vital reality of the American lawyer. It's a reality that television, in its quest for simple moral clarity, almost always gets wrong. But this focus on duty and procedure is only half the battle. The other half is the arena where it all plays out, the courtroom. And the TV courtroom is a place of high drama, surprise witnesses, and shocking confessions. It's a theater of the unexpected. But how much of that is real? Is a trial really a series of gotcha moments, or is it something else entirely? Something far more predictable and, frankly, far more boring? The answer is almost none of it. A real American trial is one of the most painstakingly choreographed and predictable events you can imagine. The single biggest reason for this, the concept that blows the entire TV courtroom drama out of the water, is a process called discovery. Discovery is the polar opposite of surprise. It's a mandatory show and tell for lawyers. Before a trial ever begins, both sides are legally required to exchange all, and I mean all of the relevant information they have. This includes witness lists, documents, emails, photographs, expert reports, everything. There are no secret files. No hidden witnesses kept up your sleeve for a dramatic reveal. If you tried to pull a surprise witness like they do in the movies, the opposing lawyer would stand up, calmly object, and the judge would almost certainly forbid that person from testifying. You didn't disclose them during discovery. Game over. This process isn't just a friendly sharing of notes. It's an exhaustive, often brutal, months-long, or even years-long ordeal. Lawyers send each other written questions called interrogatories that the other party must answer under oath. They demand documents through requests for production. And most importantly, they conduct depositions. A deposition is where a lawyer gets to question the other side's witnesses, under oath, with a court reporter transcribing every single word. This happens long before the trial, usually in a conference room. So when a lawyer in a real trial is cross-examining a witness on the stand, they already know what that witness is going to say. They've already asked them these questions. They have the deposition transcript in their hand, and if the witness changes their story by even a single word, the lawyer can say, "Isn't it true that on May 17th in your deposition, you said the exact opposite?" There's no "a few good men" moment where Jack Nicholson suddenly melts down and confesses on the stand. Why? Because his lawyer would have prepped him for hours, and the prosecutor would already know exactly what his version of the events was. There are no curveballs. The entire purpose of discovery is to prevent trial by ambush. The legal system decided long ago that justice is better served when both sides have access to the same facts and can build their case accordingly. The trial is supposed to be a contest of arguments about what the known facts mean, not a scavenger hunt for hidden clues. So when you see Mike Ross finding a smoking gun document the night before trial and striding into court with it the next day, that's pure fantasy. In reality, if he found that document and hadn't turned it over to the other side, he'd face severe sanctions from the judge, could have the evidence thrown out, and might even cause his client to lose the case on the spot. He wouldn't be a hero. He'd be a terrible lawyer who just committed malpractice. And then there's the evidence itself. On TV, lawyers shout "objection" like a magic word to stop the other side from saying something damaging. While objections are real, they aren't just expressions of disagreement. They are specific, rule-based arguments. Objection, hearsay. This is a classic. It basically means the witness is trying to testify about something they didn't see or hear themselves, but rather something someone else told them. For example, a witness can't say, "My neighbor told me she saw the defendant run the red light." The neighbor has to come in and say it herself. TV shows play fast and loose with this all the time to deliver exposition. Objection leading. This means the lawyer is basically feeding the answer to their own witness. Asking, "You were feeling scared, weren't you?" is a leading question. The proper way is, "How were you feeling at that moment?" Objection relevance. This means the question or the evidence has nothing to do with the actual issues in the case. It's designed to waste time or prejudice the jury. Objection speculation. The witness is guessing, not stating a fact. These aren't dramatic outbursts. They are technical, procedural tools to ensure the information the jury hears is reliable and follows the rules. The entire trial is governed by these dense, complex rules of evidence that take years to master. It's not a free-for-all debate. It's a slow, methodical construction of a factual record, brick by boring brick. The reality of a trial is that it's often dull. It's hours of testimony establishing a foundation. Before you can even talk about the contents of a medical report, you have to bring in a records custodian from the hospital to testify. Yes, this is a true and accurate copy of the patient's file, created in the ordinary course of business. It's procedural. It's repetitive. The most dramatic moment of a day might be a 15-minute argument between the lawyers and the judge, with the jury sent out of the room, about whether a single paragraph in an email is admissible. The drama, the persuasion is far more subtle. It's in the way a lawyer organizes these pre-approved facts into a compelling narrative. It's in the way they build rapport with the jury over days and weeks. It's not about finding a magic bullet. It's about convincing 12 people that your interpretation of the same pile of evidence everyone has seen for months is the one that leads to justice. So why does this myth of the explosive courtroom showdown persist? Because it's a magnificent storytelling device. It provides conflict, suspense, and a satisfying climax. A realistic trial would make for terrible television. Nobody wants to watch a 4-hour deposition about shipping invoices. We want to see a liar exposed, a killer confess, a hero lawyer snatching victory from the jaws of defeat with a single brilliant question. We get the story of a trial, not the reality. But this creates a profound misunderstanding. It makes us think a lawyer's main job is to be a brilliant actor and a clever detective in a courtroom. It suggests that the truth is something that is dramatically revealed at the last second. In reality, the truth is something that is painstakingly built, piece by piece, long before the courtroom doors ever swing open. This raises a critical question. If the surprise witnesses are fake, the smoking guns are a fantasy, and the trial itself is a largely prescripted event based on months of discovery, then what is the real skill of a top-tier lawyer? If 95% of all civil cases in the United States settle before they ever get to a trial, what are these brilliant legal minds like Harvey Specter actually doing all day? The real battleground of the American legal system isn't under the bright lights of a courtroom. It's behind the closed doors of a conference room. And that is where the real power, the real strategy, and the real Mike Ross effect truly lies. This is where the entire television portrayal of lawyering fractures from reality. We've been conditioned to see the courtroom as the Coliseum, where legal gladiators clash in a winner take, all spectacle for a cheering crowd and a solemn jury. But if the legal system were a sport, 95% of the games would be called off in the locker room after the teams looked at each other's playbooks and decided it wasn't worth the risk of injury. The real game is played before anyone ever steps onto the field. Think about it. In the United States, more than 97% of civil cases filed in federal court never go to trial. They are settled, dismissed, or resolved through other means. In the criminal justice system, the numbers are just as stark. Well over 90% of all convictions at the federal level are the result of a guilty plea, a plea bargain. The trial, the dramatic event that forms the entire basis of shows like Law and Order, Better Call Saul, and Suits, is statistically an anomaly. It is the exception, the Hail Mary, the last resort when all other options have failed. So, if lawyers aren't spending their days delivering impassioned closing arguments, what are they actually doing? They are negotiating. They are strategizing. They are engaged in a high-stakes, intellectually brutal game of chess where the board is a conference table, and the pieces are facts, precedents, and financial calculations. This is where Harvey Specter, for all his dramatic flair, is actually a more realistic archetype than the crusading trial lawyer. He's a closer. His primary function isn't to win in court, it's to make sure his client never has to see the inside of one. The Mike Ross effect convinces us that negotiation is about swagger and a few killer lines. Harvey walks into a room, says something impossibly cool and intimidating, throws a file on the table, and the other side just folds. "This is my offer. Take it, or I'll see you in court and bury you." It's pure theater. Real negotiation is a grind. It's a marathon of meticulous preparation. It begins months, sometimes years, before anyone sits down at that table. The first step isn't crafting a witty comeback. It's mastering the facts. This is where the real Mike Rosses of the world earn their keep. It's the process of discovery, a term that sounds exciting, but is often the most grueling part of law. It's the paper war. It's demanding every single relevant document from the other side. Emails, memos, contracts, internal reports. We're not talking about a single manila folder. We're talking about terabytes of data. Thousands, sometimes millions, of pages of documents that a team of associates has to read, analyze, and categorize. Mike Ross's photographic memory is a television superpower that makes this process seem instantaneous. In reality, it's a soul-crushing exercise in endurance. Young lawyers spend their nights and weekends, fueled by caffeine and takeout, sifting through digital mountains of corporate jargon, looking for that one email, that one line in a forgotten memo that contradicts the other side's story. That is the real smoking gun. It's not found in a dramatic witness reveal. It's found at 2 in the morning on page 8472 of a production set. And once you have that leverage, the negotiation isn't a single dramatic confrontation. It's a slow, deliberate dance. It's a series of phone calls, emails, and formal settlement conferences mediated by a neutral third party. Each side makes offers and counteroffers, not based on bravado, but on a cold, hard calculation of risk. This is the math that TV never shows you. A real lawyer isn't just thinking about winning, they're thinking about the probability of winning. They're asking questions like, what are the chances a jury in this specific county will side with us? What's the average damages award for this type of case in this jurisdiction? How strong is our key witness? Is she credible? Will she fall apart under cross-examination? How much will it cost to take this all the way to trial? Expert witness fees, court filings, depositions, the senior partner's billable hours. It can run into the hundreds of thousands, even millions of dollars. So the calculation becomes, is it better to accept a guaranteed settlement of $5 million today? Or risk going to trial where you might win $20 million, but you also might get nothing and be stuck with a $2 million legal bill? That is the brutal reality facing every client. Trial is a gamble. A settlement is a certainty. A good lawyer's job is not to be a gambler. It's to be a risk manager. They have to advise their client on the smart bet, even if it's less satisfying than a dramatic courtroom victory. The bluff, Harvey Specter's signature move, does exist in this world, but it's a far more dangerous tool than television suggests. On Suits, a bluff is a display of pure confidence. In the real world, a lawyer's most valuable asset is their reputation. If you get a reputation as a lawyer who bluffs without the facts to back it up, opposing counsel will stop taking you seriously. They will call your bluff every single time, forcing you into expensive, time-consuming litigation that you were hoping to avoid. The most effective bluff in real life isn't a threat. It's a calm, reasoned presentation of the facts that lets the other side see for themselves how badly a trial could go for them. It's not, "I'm going to bury you." It's, "Here are the 3 key documents that undermine your entire case, and here is the sworn deposition testimony from your own CFO that directly contradicts your public statements. Given this, we believe a jury will find against you. Let's find a number that saves us all the time and expense of proving it." This is the intellectual rigor that the Mike Ross effect completely obscures. It replaces the image of a diligent, analytical strategist with a charismatic gambler. This has real-world consequences. Clients, having watched a marathon of legal dramas, can develop wildly unrealistic expectations. They might see a reasonable settlement offer as a sign of weakness from their own lawyer. They might push for their day in court, imagining a Hollywood ending, without understanding the enormous financial and emotional cost of the journey. They want their lawyer to be Harvey, to walk in and dominate, not realizing that the quiet, unassuming lawyer who spent 400 hours preparing and advises a pragmatic settlement is the one who is truly serving their best interests. The work is a grind. It's a war of attrition fought with motions to compel, requests for admission, and interrogatories. It's about wearing the other side down, increasing their legal costs, and exposing the weaknesses in their case piece by piece, until settling becomes their most logical option. The victory isn't a not guilty verdict echoing in a silent courtroom. The victory is a quiet phone call, a signed agreement, and the knowledge that you've navigated your client out of a storm and into a safe harbor, all without ever having to set foot on the treacherous seas of a jury trial. So the real lawyer is a master strategist, a risk manager, a warrior of the paper war, operating in the shadows of the conference room. But this entire system, this delicate dance of negotiation and settlement, is built on a foundation of rules. Rules of evidence, rules of professional conduct, ethical lines that cannot be crossed. On television, however, those rules are treated as mere suggestions. Our heroes, Mike and Harvey, bend and break them constantly in the service of their client, and they almost always get away with it. But what happens when the strategy involves breaking the actual law? On television, it gets you the win. In the real world, it gets you disbarred. And that is where the Mike Ross effect shifts from being a mere distortion to something truly dangerous.